Hi everyone. So welcome to the fourth session of constitutional law. So till now what we have discussed, we'll just have a quick look and then we'll move ahead with today's class. So in today's class we are discussing Article 20, Article 21 and also writ if time permits. And we have discussed the important topics like 12th schedule of the constitution, fundamental right, DPSP, fundamental duties, constitutional bodies, emergency provision, judiciary, and also have taken into consideration certain contemporary legal development which is kind of which forms the part of our exam, or which is like more kind of related to all the legal events which keeps happening in our country. For example, like if a law is coming, so first thing which you check is whether it is constitutionally valid or not, or whether any law is in contravention with fundamental right or not. So keeping that in mind, current affairs or contemporary legal development plays a very important role. Then we also discussed about the preamble. We discussed this every aspect or every details which is given in the preamble, like what is sovereign country, what do you understand by socialism, secularism, democracy, democratic republic, then what is justice, which includes social, economic and political justice. Then also we discussed about liberty of thought, expression, belief, faith, worship, equality, where we are looking for equality of status and opportunity, fraternity of all, and at last we are looking for unity and integrity of the nation. Then we discuss the concept of state, because fundamental rights are being guaranteed by the state. So it is the state which gives us the fundamental right. So in case there is a violation, in case there is a breach, we can always file a writ against the state. So for that purpose, whether state has, or whether your fundamental right has been violated or not, or if it has been violated, whether it has been violated by state or not, that is very important for us to understand. That is why Article 12. Then we also discuss Article 13, which defines what is law. So the basic crux or basic idea which we have to keep in mind, keeping into consideration Article 13, is that whichever law is there in our country before the constitution came into picture or after the constitution came into picture, it has to be in relationship with fundamental right. It shall not violate the provision of fundamental right, and if it violates the provision or aspect of fundamental right, so to the extent it violates, it can be declared as unconstitutional. Then we discussed equality before law. So there are two aspects under Article 14: equality before law or equal protection of law. Equality before law is more of a negative concept, equal protection of law is more of a positive concept. Then we also discussed Article 19, which is freedom. So here, when we take into consideration freedom, freedom of speech and expression, we always often see in news from our personal perspective also, that what sort of freedom we are having from media's perspective also. So keeping all these in mind, you always see 19(1)(a) in news. Then you also see how the reasonable restrictions can be imposed on these freedom. So these are some things which we have done in last three classes of constitution. Now today we are going to talk about Article 20. Why Article 20? Article 20 is very important from CLAT perspective, as I always say, that CLAT, or for that matter any law entrance examination, they do ask questions from Article 20. And CLAT, if you go back and check or analyze last 5 years ka papers, you'll get to see that they have asked questions from Article 20. So when we take into consideration Article 20, it is a kind of, it stands as a critical safeguard, you can say, for those who are accused of crime. It ensures that there has to be fairness, it ensures that there has to be justice, and it also ensures that there has to be protection against arbitrary state action. If you take Article 20 into consideration, Article 20 are having three clauses. First is Article 20, Clause 1, which talks about ex post facto law. The second one is Article 20, Clause 2, which talks about double jeopardy. And then we have Article 20, Clause 3, which talks about self incrimination. So, keeping these things in mind, you always need to remember that prohibition of retrospective criminal law or ex post facto law is 20, Clause 1. Protection against double jeopardy is 20 clause 2, and protection against self incrimination is 20 clause 3. So what do you understand by ex post facto law? So Article 20 clause 1 says no person shall be convicted of any offense except for violation of the law in the force at the time of the act. Moreover, no one can be subject to a penalty which is greater than what was prescribed by the law in force at the time of the offense. So the idea is no person can be convicted or penalized for an act that was not considered an offense when it was committed. For example, a very hypothetical situation. Let's understand. Again, a hypothetical situation, I'm saying that suppose the murder is not a crime. It is nowhere mentioned as a crime under our criminal law. Now, Mr. X killed Mr. Y. Government saw this and government felt like this seems to be a heinous thing, so let's make it as a crime. So government made it as a killing of a human being as a crime, being called as murder or culpable homicide, whichever category it will fall. Now, this law will not be applicable on Mr. X because when Mr. X killed Mr. Y, there was no law per se which was defining it as a murder, or there was no law per se which was saying that killing of a human being is an offense. So he cannot be held liable for something which wasn't there when he did that. So this is one aspect of 20 clause 1. Then the prohibition under 20 clause 1 applies to conviction and punishment. It ensures that no individual faces penalties under laws enacted after the alleged offense. If an act was legal when performed and subsequently if it has been criminalized, then also there cannot be a retrospective application of the same. But when we take into consideration retrospective application, you have to keep this in mind that it is always applicable in case of criminal law. It is not applicable in case of civil law. So civil law, taxation, these these are the areas where this 20 clause 1 protection does not apply. The best way to understand this through an example would be, I don't know how many of you remember this or not, but during demonetization, government had told people that even if you have some money which you have not disclosed before the government, or where you have not paid taxes for that money, you just come to us, disclose the sources from where you have got this money, pay the fine, pay the taxes, and you are free to go. So this is where there's a retrospective application. So under civil law there can be a retrospective application, but under criminal law there cannot be a retrospective application. So this is with respect to article 20 clause 1. Then the second one is 20 clause 2, which is covering the principle, or you can say aspect of double jeopardy, which basically means that no individual is prosecuted and punished for the same offense twice. Basically, this means that suppose if a person has committed murder, he had already suffered or he had already got the punishment and he had spent his the time period whichever was given to him in jail. Now again you cannot punish him for the same offense again. So double jeopardy protection applies exclusively to proceeding before uh, judicial tribunals or court. Again, this is not applicable in case of administrative actions or departmental actions. So, for example, suppose there is a person who has done something wrong, and there is two proceeding going on. One is departmental proceeding where the department, in order to make or in order to handle the situation, has suspended him. Now this person is also being prosecuted and punished by the court, so he cannot take the defense saying कि department ने तो मुझे punish कर दिया है. So keeping that in mind, court proceeding would not be applicable. No, departmental proceeding, administrative proceeding is not covered under double jeopardy. Double jeopardy is where there's a prosecution, there's a punishment by court. It can be a judicial court, it can be a tribunal, but it has to be there. And it actually protects repeated prosecution for the same offense based on, you can say, same thing, like a person has already committed a murder, you cannot punish the person again for the same murder. So this is what is double jeopardy. But again, if there's another catching thing in this, suppose there was a prosecution and after prosecution the person wasn't punished but was acquitted by the court. So here the acquitted part is there, punishment wala part is missing. So if the person has been acquitted, later on if it is being found that he actually killed somebody, So in that particular case, if again proceeding is started has started and the punishment has been given to him, he cannot take the defense of double jeopardy, because for double jeopardy there has to be punishment plus prosecution plus punishment. But in the last example, there was a prosecution but acquittal. So keeping that in mind, he cannot take the defense of double jeopardy. And the last one is 20 clause 3, which says protections against self incrimination, which says no person sorry, accused of any offense shall be compelled to be a witness against himself. This there are parallel provision which is there under Indian Evidence Act and under Criminal Procedural Code also. So it basically says it prevents the individual from being forced or compelled to provide evidences against themselves. This principle actually aligns with the due process, and it is very much integral to ensure fairness in criminal trial. जनरल परसेप्शन है ना लोगों का कि इफ पुलिस हैज अरेस्टेड यू, police give will give you third torture, a third degree torture. The general people perception is there. So out of fear, people tend to confess their crime. So if the confession has been made before the police officer, it is not a valid confession because the person must have given it under the fear. But if the confession has been made before a judicial magistrate, so in that particular case, it is a very much valid confession. But confession given before police is not a valid confession. But there's another catching thing. Suppose if a person has, you know, not confessed basically, but a person has actually told the police officer that how he committed the crime, उसने कहाँ पे सारे weapons छुपाए हैं या whatsoever thing he has done, he is explaining it to the police. Basing on his statement, if police starts doing their own search and investigation and they find all the evidences, so there this can be used against that person, and he cannot say that this is violation of his fundamental right and he is protected under article 20 clause 3. No, because he has not confessed. Police did their own investigation search and they found the evidences, so basing on that they can prosecute him. So protection here extend to both oral testimony and documentary evidences that may incriminate the accused. uh, the clause applies exclusively to criminal cases. Again, it is not applicable to civil disputes. And evidence voluntarily provided by the accused is admissible and does not violate Article 20, Clause 3. So, when you take into consideration 20, Clause 1, 2, and 3, this is very important from your exam perspective. So, always try to remember what the three clauses are saying. What is the idea behind these clauses? You can go back and check past year paper also where they have asked questions from this and you can solve it. Now the next one is Article 21. So Article 21, right to life and personal liberty, is assured by the Constitution under 21. This is a very important article and it has several things attached to it, or you can say it has several implications for the citizens of India. Article 21, protection of life and personal liberty, which basically says no person shall be deprived of his life or personal liberty except according to the procedure established by law. So the fundamental right is available. This fundamental right is available to everybody, every person, citizens, foreigners also. It provides right to life, it provides right to personal liberty. It is one of the most important right that the Constitution guarantees. It is also being called as the heart of fundamental rights. It is something which kind of give you every sort of thing which you need. It is not like about the right to survive. It also gives you a right to have a dignified life, a right to have a meaningful life, you can say. When we take into consideration Article 21, it has been interpreted differently in different cases. For example, especially the word procedure established by law. So there are two famous cases. One is A.K. Gopalan and the other one is Menaka Gandhi. So in AK Gopalan case, Article 21 had a narrow scope, or you can say it was very much confined to the definition. Procedure established by law means government ने जो law बना दिया, that is okay. So here the Supreme Court has stated, Constitution had embodied the British ideas of personal liberty rather than the American ideas of due process. And here the idea or crux you can say was that if government has made a law, you are supposed to abide by the law. But in Menaka Gandhi case, where her passport was seized without giving her any justification, the court actually interpreted it very openly. And court said that Article 19, 21, or 14 cannot be interpreted in a watertight compartment. It has a wide scope, including many rights. And when you are taking into consideration procedure established by law, it means it has to be procedure established by law is nothing but due process of law. That means every action of the government has to be just, fair, and equitable. Court also stated the concept that Article 14, 19, and 21 forms the golden triangle of the Constitution, and wherever 21 is in question, 14 and 19 will come into picture. Wherever 19 is in question, 14 and 21 will come into picture. So you cannot take away one article and discuss the other two. All the three forms a triangle and a very important aspect, and it has to be taken into consideration. So the interpretation in Menaka Gandhi case, it was like that there should be law, and the law should be fair, reasonable, just. The article 14, 19, and 21 are connected, which is the golden triangle. The personal liberty in Article 21 was given widest amplitude. So, if you look at the judgment of Supreme Court, right to life includes right to privacy, right to pollution-free environment, right to pollution-free air, right to clean water, right to you can say education. 21 clause A. Every aspect of life is being covered under Article 21. Then the next fourth point says Article 20 and 21 cannot be suspended during emergency. So, first thing which you need to keep in mind is your fundamental right never gets suspended. What gets suspended is your right to approach the court. So, in case of emergency, you cannot approach or file a writ petition for the enforcement of your fundamental right. But when the question is with respect to Article 20 or 21, you can approach the court even in case of a situation of emergency, and it is available to foreign citizens as well. So, this is all about Article 20 and 21, which you can go ahead and read and also have a fair idea as to what this includes, how CLAT have asked questions from Article 20 and 21. Now, there will be one more class of constitution where we'll be taking into consideration the writ petitions, and if they're writ petitions or maybe emergency provisions. So basic idea of all, and then we are done with the constitution. So this is all about today's class, guys. Thank you. Whatever questions you have, you can post it in chat box. I'll get back to you. Thank you so much. See you in the next class. Thank you.